Hey everyone, welcome back to my channel Beyond the Briefcase. I hope you're doing well. So today we'll be discussing section 1 to 20 of CPC. We'll be looking at what exactly the sections are, and we'll also discuss various orders which are related to sections 1 to 20. I guess various sections from 1 to 20 they don't have precise orders, but we'll discuss section 1 to 20. So as you know that in CPC we have total 158 sections, we have 51 orders and various rules. Also, we'll be discussing in such a way that if you are preparing for any competitive examination, also if you are preparing CPC for your litigation practice, it will be very helpful for you. So let's start with the video. So initially, as you can see that CPC is lengthy, but trust me, it's a very logical subject when it comes to apply this particular subject in law in litigation practice. Also, when you prepare for any competitive examination. So also, I'll be telling you that. So first of all, we'll be taking this particular discussion in various episodes. Today is our first episode. I'll be coming soon with various episodes as well. So always remember that beat any act, but the section one of any act it plays a very important role because section one of any act it tells you that in which states in which part of India this particular act applicables. So when we talk about CPC section one, which talks about short title commencement and extent, it came in the year 1st January 1909, and that's the important thing which I have highlighted. Do make sure you read this thing properly because it does come in the competitive examination in judicial examinations. Then in it extends in the whole of India when we talk about CPC, but except in state of Nagaland in their tribal areas. So as you know that state of Nagaland, various laws does not applicable in that particular state. Also, when in the initial era, when we talk about history, Nagaland had a agreement, had a contract with the Indian government, and that's why many of the laws they are not applicable in the state of Nagaland, and for the same reason, they merged with India. Now, coming to the second section, section two, which deals with definitions. Now, definitions are very important. This could come in your examinations as well, but also you should know all the definitions. You have to be very thorough with the definitions, or else your basics won't be clear. Now, the section on the code itself it includes rules, as we all know. Section 2 clause 2 talks about decree. So decree is nothing, see, don't get confused, decree and judgment both are different thing. So when we talk about decree, it's nothing but a formal expression of an adjudication, and the which court expresses, right? Also it determines the right of the parties with regard to the matter. You must be knowing that when we talk about civil cases, you get a decree, right? So let's say there is a process. In between the process, first you'll get the decree, then you'll get the judgment. So decree comes first, then comes the judgment. In that way, please understand that it will be very easy for you. Also, 2 points which are very important for decree. Point A: any adjudication from which an appeal lies as an appeal from an order. Now, again, there's a difference between order and a decree. Any order of dismissal for default. Explanation: a decree is a preliminary when further proceedings have to be taken. See, just now you mentioned, let's say there is a line, okay? In the end of the line, you will get the judgment. But the initial thing which you will get from the court would be decree. That's what they have written in the explanation itself. A decree is a preliminary when further proceeding has to be taken before the suit. So it's the first thing which you will get from the court until the case disposed of. Then again, it is a final when such adjudication completely disposes of the suit. Now, decree could be partly preliminary and partly final. So it could be both. Now, section 2, clause 3 talks about decree holder. I'll tell you there are two terms, okay? Pay attention to these two words. The first being decree holder, and the second being decree data. So let's say there are two parties, A and B. Okay, listen very carefully. So when A gets the judgment in his favor, then A will be called as decree holder. Okay, but B failed to get the judgment in his favor, so B will be called as decree dater. Dater, DEBT, or dater. Okay, so decree holder, decree dater. I hope you are clear with these two terms. Let's read the definition once. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. Just the same thing which I mentioned just now. So, see, if you read CPC very carefully, right, if you make proper diagrams and charts, it will be very easy subject for you to understand. Now, clause 4, which talks about district. So there are certain limitations, jurisdiction of the court, and there are certain courts which, and for those courts they have their own jurisdiction, and we have several districts, and for several districts we have courts. That's what they have mentioned. Clause 5, foreign court. It means a court situated outside India and not established or continued by the authority of central government. And we all know that we don't have such concept as of now. Again, foreign judgment. Again, the judgment passed by the foreign court. So it's a basic thing to understand. Now, government pleader. So, government pleader means your public prosecutor, your special public prosecutor, right? People who represent government in front of, in judiciary, in court, and we call those people as a government pleader. So, government pleader includes any officer appointed by the state government to perform all any other functions explicitly imposed by this court. And government pleader also any pleader acting under the directions of government pleader. So, as I mentioned, Solicitor General, Advocate General, they all are government pleaders. High Court, as you know, India, again, as we know, judge means presiding officer of a civil court. Now comes judgment. So, judgment means the statement given by the judge of the grounds of a decree or order. So, let me tell you something. As we discussed that, let's say there is a line of procedure. The first thing which you would get is decree or an order. The last thing would be the judgment. So judgment is being given by the judge on the basis of decree and order. Also, I'll take an example, then you'll get the clarity what exactly the judgment is. So let's say there was a criminal case, okay, and in that criminal case, section 420 of IPC cheating, section 34 common intention, section 476, everything is involved, okay. So initially when the case was going on, the court gave various order of maybe adjournment, order of maybe pleader change, it could be anything, right? But lastly, when the case got disposed, the judge would give you a judgment of, let's say, 20 to 30 pages, right? Now, in that 20 to 30 pages, everything will be mentioned. Everything it means the fact of the case, the provisions involved in that particular case, the precedents which the court relied upon, the precedents which the parties relied on, right? And the conclusion obviously given by the judge that what was the legal logic behind the judgment. So that's what we say judgment is. Again, judgment data, the person who loses the decree against whom decree has been passed. I mentioned judgment holder and judgment data. Legal representative, let's say I am unable to go to court, I'll give a power of attorney to other person that please you represent me represent me in the court of law, and that particular person will appear on the behalf of me in the court of law and will call that particular person as legal representative. Now, mesne profit, it's a very good term. Let me tell you something about mesne profit. You will see this question in every competitive exam, so it is the most important, important concept. Make sure you read this concept with utmost sincerity. That's why I've marked it. So I'll tell you what exactly the Mesne profit is. Let's say A is a landlord and B is tenant. Okay. Now A has given the home to B. Okay. Now, no, leave it. So let me first read the definition, then I'll explain you people because you'll get confused. Okay. So mesne profit of property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received their form. So let's say there's a property. Okay, that property is owned by person A. Okay, but person B is living in that property by having a wrongful possession of that property. Now, when B is living in that particular property by having wrongful possession, the amount of money which B is earning, right, that money would be called as mesne profit, right? Let's read further. Uh, of such property actually received or might with ordinary diligence has received therefrom. See, received. They have used this word received. Together with interest on such profit, but shall not include profit due to improvements made by the person in wrongful possession. That's what we call mesne profit, which I mentioned. Movable profit, movable property, please read it properly because they include growing crops. They do ask in judicial examinations. Order, formal expression by any decision on civil court, which is not a decree. So there's a difference between order and decree. Pleader, again, a person who represents you in the court. Vakil, advocate, attorney of high court. Prescribed, you can leave, just you can read the rules. Public officer, it could be anyone, every judge, every member of all India service, IPS, IAS, every commission or gazetted officer, all those things. So please read all those things. Every person who holds any office by virtue of which he is empowered. Then rules formed and contain the first schedule of CPC. Share in a corporation means shall be deemed to include stock, debentures, or bonds. Signed, you can see stem and all those things. Now, subordination of quotes. Now, it is very important for you to understand that when we talk about subordination, there is a hierarchy of quotes. Now, when I say hierarchy of quote, so let's start the hierarchy by the Supreme Court itself, right? Just a second. Yeah. So we have Supreme Court. We all know that Supreme Court is the number one court in India. Every court follows the precedent rulings of Supreme Court, right? So Supreme Court is a superior court we have in India. Now, after Supreme Court, we have High Court, exactly, right? So every cases from High Court goes to Supreme Court. Then comes District Court, right? Then comes Lower Judiciary, Civil Court. So we have low judiciary, civil court, then district court, then high court, then supreme court. That's what we call as subordinate of courts, hierarchy of courts. That let's say there is a case which is going on. So see, ultimately every case will go to first civil court. Okay. After civil court, you can appear before the supreme court, district court. Sorry, after district court, you'll go to high court. Then lastly, you will go to Supreme Court. And in, as you know, the concept of mercy petition, you can also appeal before the President of India. But in some of the cases only, you can appear before the President of India. Not for every case. So that's what we call subordinates of courts. Now, Section 4, savings. So, in the absence of any specific provision to the contrary, nothing in this code shall be deemed to limit or otherwise affect any special or local law. So, you must be knowing contradiction between special and local law. That if there is a contradiction between special laws and local laws, which will prevail, nothing else. Then comes section 5, application of the code to revenue codes. See, all the sections are not that much relevant, but you should have basic understanding of all the sections. Then, oh, sorry for the disturbance here. So, revenue code, as you know, that it means a code having jurisdiction under any local law to entertain suits or other proceedings relating to the rent, revenue, profit of land used for agriculture purposes, but does not include a civil code having a original jurisdiction. So let me tell you something that we also have commercial courts, we also have tribunals. So see, we have tribunals, we have separate courts for different purposes, right? We cannot rely on single court because now our population has been grown so much. We have population of 140 cr plus, and we have very limited number of courts. So we do need tribunals and special courts to deal with those cases. Section 6, pecuniary jurisdiction. So I'll tell you what exactly the pecuniary jurisdiction means. So jurisdiction which will be decided on the basis of suits of the amount of the suit and the value which is present in the jurisdiction, or the subject matter of which exceeds the pecuniary limits or its original jurisdiction. So basically it's nothing, the amount of the suit, and that decides the jurisdiction. That's what we call pecuniary jurisdiction. Provisional small cost codes you can leave, it doesn't it's not that useful. You can have a basic reading, that would suffice. Now presidency small cost codes, we do have orders for that, right? We'll be seeing that orders as well, which is related to small cost codes. Coming directly to the section 9, courts to try all civil suits unless barred. Now there are two explanations, right? So the court can shall entertain all the cases if they have jurisdiction to try all the suits of civil nature, excepting suits of which their cognizance is either explicitly or impliedly barred. So see, there are certain limitations that court cannot touch those matters, and they don't have jurisdiction for all those matters. Explanation 1. So when we talk about explanation 1, it says that a suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So this is the first thing which I am highlighting, and it's a very important point. Religious rites or ceremonies, right? Explanation 2. For the purposes of the sections, it is immaterial whether or not any fees are attached to the office referred to explanation 1, or whether or not such office is attached to a particular place. So do remember all these two explanations, that will suffice. And this is the state amendment which Maharashtra did for with regard to section 9. So it's not mandatory, but yeah, if you are from Maharashtra and if you're appealing for judicial examinations of Maharashtra, then it becomes very necessary for you to read this particular section. They do ask amendments in the judiciary examinations as well. Then coming to the section 10, stay of suit. So no court shall proceed with the trial of any suit in which the matter in issue is also directly substantially in issue is a previously instituted suit between the same parties, or between parties under whom they or any of they claiming litigating under the same title. So let's say there is a same suit, okay, and the same parties, and the same case is being going in another court as well, right? That in those situations, there is a provision of stay of suit, that one of the court they can stay, they can put stay on that particular suit. So that's what we call the stay of suit. Now when we read the explanation, the pendency of a suit in foreign court does not preclude the courts in India from trying a suit founded on the same cause of action. Again, foreign court. See, I'll tell you that in today's era, there is only one sort of possibilities that divorce cases. Let's say there is a couple of the couple, they belongs to India. They are Indian residents. They went outside for the job. Now they want to file divorce in the foreign court. So in that manner, they want to explain this particular explanation, which is related to Section 10, stay of suit. Now comes a very important concept which I am highlighting right now. Res judicata. Do read it very carefully. See, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly substantially in issue in a former suit between the same parties, or between the parties under whom they or any of them claim litigating under the same title. See, again, the same thing which I mentioned, same suit, same title, and there are two concept, which the first being former suit and the subsequent suit, right? So if the same thing is there, then again the court has jurisdiction to put a stay on the particular suit. That's what we call res judicata, that first you solve the first case, don't jump into the another suit. Then we do have explanation 1, explanation 2, explanation 3, 4, 5, 6, 7, and 8. So, starting with first, the expression from a suit shall denote a suit which has been decided prior to a suit, in case whether or not it was instituted prior thereto. To read all these 8 explanations, it plays a very important role also in judicial examinations. You'll get an MCQ saying that they'll give you 4 options and they'll ask what was written in explanation 5 of section 10. So that's how they frame the questions, right? Moving ahead, bar to further suit, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular case or cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which the court applies. So here it is very important to understand the cause of action, the main matter for which the court instituted, which you instituted a suit, right? Again, the same thing, I would say that why this section 10, 11, 12 is necessary, because see, courts, they don't have time to entertain the same suit again and again, right? Once they dismiss your suit, it becomes your obligation to, go and appeal in higher court. For the same reason, they have mentioned all these sections. Section 13, when foreign judgment not conclusive, a foreign judgment shall be conclusive as to any matter thereby directly adjudicate upon between the same parties. Again, it doesn't play a very important role because now we don't have this concept. So you can just have a small read and you can move forward. Presumption as to foreign judgments, again, you can just have a small reading and that's would suffice. Now comes a very important part, which is place of suing, section 15, court in which suits to be instituted. Now, see, as I mentioned earlier, the jurisdiction of the court plays a very important role. You'll have to see before filing the case in the court whether the court in which you're going to file the case, whether that court is competent enough to try that case or not, right? So, you have to be very careful when you see the jurisdiction of the court. Section 16, suits to be instituted where subject matter situate. So where the cause of action happened, where the whole case happened, that's where we talk about the discretion of the court. So there are certain points which you have to read: for the recovery of immovable property without trying and profit, for the partition of immovable property, for foreclosure, determination of other right, for compensation for wrong to immovable property, for the recovery of movable property actually and distrend or attachment. So these are the situations where this section 16 will come into the effect, and do read it properly, right? Section 17, also if you see the explanation section of section 716, in the sections, property means property situated in India. You cannot claim property outside India, right? 17, suits for immovable property situate within jurisdiction of different courts. Again, let's say your property is situated in other district, uh, in other court. So in that situations, you will have to be very careful while filing the case. You'll have to see the discretion, jurisdiction of that particular court where your property exists. Section 18, place of institution of suit where local limits of jurisdiction of courts are uncertain. Again, the place of institution of suit where local limits plays a very important role. Again, the jurisdiction plays a very important role. You'll have to see whether the court where you representing the case is competent enough or not. Section 19, suits for compensation for wrongs to person or movables. So, where a suit is for compensation for wrong done to a person or to a movable property, if the wrong was done within the local limits of the jurisdiction of one court, defendant resides or carries or business or personally works for gain within the local limits of jurisdiction of another court, the suit may be instituted at the option of plaintiff in the either of said court. So in that situation, you'll get 2 options, right? Whether you reside where you are working or carrying out your business, also whether it is in the local limits of jurisdiction or not. Let's see the illustration. A residing in Delhi beats B in Calcutta. B may sue A either in Calcutta or in Delhi. So B has option of both the places where he can sue A. but I would suggest that he should go to Calcutta, because after getting beaten from A, he'll have to go to hospital as well. So it would be very comfortable for B to go to Calcutta for this particular case. Now, coming to the last section of today's segment, which is section 20, other suits to be instituted where defendants reside or cause of action arises. So, from the title itself, you can understand that you can institute a suit where defendants reside or the cause of action arises. So, for this, let's see the illustration. A is a tradesman in Calcutta. B carries on business in Delhi, right? B, by his agent in Calcutta, buys goods of A and requests A to deliver them to the East India Railway Company. A delivers the good accordingly in Calcutta. A may sue B for the price of goods, either in Calcutta, where the cause of action has arisen, or in Delhi, where B carries a business. So, from the title itself, the section was very clear. Also, read a explanation: a corporation shall be deemed to carry on business at its sole or principal office in respect to any cause of action arising in the place where it has also subordinate office in the place. So we have finished section 1 to 20. I have also highlighted various important parts, right? Also, do see when you read CPC, it becomes your obligation to read the provisions, explanations, right? To subclauses, see this all the clauses which they have mentioned, all the keywords which I have highlighted. So when you read, when you keep all these pointers in your mind while reading, it becomes very easy for you, right? So thank you so much. We'll be meeting soon with another sections. Do share this video with your friends who wants to have a good understanding of CPC, right? So thank you so much for watching my video, and stay tuned for more informative videos.